The International Criminal Court is now in session, hosting the ICC Moot Court Competition 2019 English version. Please be seated.
Good afternoon. I would like to greet the teams for the counsel for Dr. Danny Targaryen, the counsel for the prosecution, and also counsel for the state of Astapur. I would also like to welcome the, of course, courtroom staff, the security officers who diligently are making sure that we're all safe, as well as, of course, you, the members of the public who are in the public gallery. For those of you who could not make it into the public gallery, those of you who are in the seats in the press briefing room, as well, of course, the participants to the ICC Moot competition who are all attending this hearing. And also for those who are outside and who are following these proceedings via the internet. I would like the court officer to please call this case.
Thank you, Mr. President. We are sitting in an appeal session regarding the defense of Dr. Danny Targaryen against the pretrial chamber decision on the confirmation of charges. Charges of aiding and abetting the crime of aggression. Crimes were allegedly committed in the context of the situation relating to the crime of aggression against Bravos, ICC Moot Court Competition 2019 English edition.
Thank you. Now, on behalf of the chamber, I would now ask the parties and the participants in this hearing to introduce themselves, and I think I'll begin with counsel for the defense.
May it please the court, I appear for the defendant. My name is Kayla Varley, and I appear alongside my co-counsel, Mr. Raphael O'Leary. May it please the court.
I now turn to the prosecution. Can you present members of your team?
May it please the courts. My name is Joshua Young, and I appear on behalf of the prosecution with my learned co-counsel, Mr. Luke Yan. May it please the court. Thank you, Your Honors.
Thank you. I now turn to counsel for Astapur. Can you introduce your team as well?
Mr. President, honourable members, my name is Anna Ruby, and I represent the state of Astapur, along with my co-counsel, Elizabeth Hartley.
Thank you. The team of the registry is represented today by Court Officer Caroline Bossett and Miss Iona Maruru, Miss Sophie Mercer, and Ms. Tina De Brucker from the Goethe Center for International Legal Studies. Finally, let me introduce the bench. To my left is Simon De Smith, and to my right is Chitrangada Singh. I am the judge in this case, Jeffrey Henderson. Now, the chamber will now proceed consecutively with the three issues shaping the subject matter of today's hearings. Being mindful of the public nature of these proceedings, I would ask that the court officer please read the agenda that was established by the pretrial chamber.
I'm sorry. Thank you, Mr. President. This case arises out of allegation of crime against humanity committed on the territory of Bravos to the east, bordering the Stormy Sea, Silanta to the north, and Astapur to the west. All states are parties to the Rome Treaty and each ratified the Kampala Aggression Amendment in January 2017. The ICC prosecutor determined that there was a reasonable basis to proceed with an investigation into whether the Astipur airstrike against Bravos constitute the crime of aggression as defined by the 2010 Kampala Amendment, Article 8 bis of the ICC statute. She further concluded that the jurisdictional requirements for pursuing a case under Article 15 bis of the ICC statute were satisfied since Astipur, Bravos, and Silanta had all ratified the Kampala amendments, which came into force for them prior to the acts in question. 1. Pursuant to Article 15 bis 6 and 8, the prosecutor notified the UN Secretary General of the situation on August 5, 2018. After the 6 months clock had run without the Security Council making a determination that Astipur had or had not committed aggression in its airstrike against Bravos on February 6, 2019, the pretrial division granted the prosecutor's request to authorize an investigation and to issue a warrant for the arrest of the defendant, Danny Targaryen, for aiding and abetting the crime of aggression under Article 8 bis and Article 25(3)(c of the ICC statute. The next day, Silanta transferred Dr. Targaryen to the ICC's custody, and the ICC immediately appointed her defense counsel pursuant to Article 55 of the ICC statute. Actions against James Bannister and other Astipur officials are proceedings separately. The appeals chambers seeks submissions of all parties and participants on the following issues. A. Whether the indiscriminate nighttime search of the defendant's home and the seizure of her personal computers without a warrant or even legislative authorities render the evidence inadmissible. B. Whether the humanitarian intervention described in the pretrial chamber's decision was of the, and I quote, character, gravity, and scale to constitute a manifest violation of the Charter of the United Nations, end of quote, as required for the prosecution of the crime of aggression under Article 8 bis of the ICC statute. C. Whether the crime of aggression, which was intended by the Kampala amendments to apply only to high-level governmental officials in a position effectively to exercise control over or to direct the political or military action of a state, can be applied to a private lawyer who provided the government legal advice on the legality of contemplated military action.
Thank you, court officer. Before I ask and I call upon the defense to begin, I would just like, of course, to remind all of the parties, the participants, that you really should speak as slowly and as clearly as possible and to pause between questions so that everyone can clearly follow the proceedings. So having said that, I will now give the floor to counsel for the defendant to present its case and to discuss the 3 issues that are before us.
Mr. President, Your Honours, may it please the Court. This case is about the arbitrary interference by state actors with individual rights and this Court's willingness to stand over it. The defendant is a lawyer and academic. She is being prosecuted for one of the most serious international crimes on the basis of airstrikes carried out by the state of Astipur. her only contribution, the provision of independent legal advice. Mr. President, today this court has an opportunity to reinforce the fair trial protections afforded to defendants before this court, an opportunity to recognise the formation of a new rule of customary international law, and an opportunity to resist the attempt to widen the Rome Statute definitions of individual criminal responsibility. To this end, Defence Counsel asks that the court grant this appeal on 3 grounds. First, that the evidence against the defendant is inadmissible pursuant to Article 69(7) of the Rome Statute. Second, that there was no crime of aggression, as the airstrikes did not have the character, gravity, and scale to constitute a manifest violation of the Charter of the United Nations. And third, that the defendant does not satisfy essential threshold requirements for aiding and abetting the crime of aggression. If it pleases the court, I will move to my first submission, and this concerns the evidence seized from the defendant's home. Mr. President, given the severity of the violation of the defendant's rights and the damage that the admission of this evidence would have to the integrity not just of these proceedings, but potentially to all proceedings before this court must exclude the evidence. I have 2 submissions here. First, that the evidence was gathered as a result of a violation of the defendant's right to privacy. And second, that admitting that evidence would be antithetical to and would seriously damage the integrity of these proceedings. But at the outset, it is submitted that the court must not have regard to the contents of the memorandums themselves, but to the circumstances in which they were gathered. At paragraph 43 of the Lubanga Bar Table decision, the trial chamber said that the probative value of evidence cannot inform this court's decision on the admissibility of evidence under 69(7), and in fact that to do so would be impermissible. Therefore, I ask this court not to have regard to any probative value that the prosecution may ask the court to ascribe to the evidence, but rather I would ask the court to have regard to the circumstances of the defendant's right being violated. To move to the first submission here then, and the defendant's right to privacy was violated. At paragraph 333 of the appeal chamber judgment in Bemba et alia, the court said that there is a violation of the right to privacy where evidence is gathered as a result of a disproportionate interference with that right. And here, the interference with the defendant's right was disproportionate. At paragraph 13 of the pretrial chamber's decision, it is set out that Solantan authorities unlawfully entered her family home in the middle of the night. They indiscriminately searched her possessions. They indiscriminately searched her family's possessions. And they seized computers, not just her work computer, but all computers in the home. In those circumstances, it is submitted that this was a disproportionate violation with her right to privacy. But second, and more crucially here under the test, it is submitted that admitting this evidence would be antithetical to and would seriously damage the integrity of these proceedings. And it is admitted that this was such a severe violation of the defendant's rights that admitting the evidence would damage not just these proceedings, but the rule of law itself. At paragraph 30 of the appeal chamber judgment in Lubanga, the chamber set out that the court will protect against violations of rights which are odious and repugnant to the rule of law and to the defendant on trial. And this is an essential aspect of the integrity of criminal proceedings, because otherwise, the administration of international criminal justice before these courts lacks any legitimacy. At paragraph 47, then, of the Lubanga trial chamber decision on the admission of material from the bar table, it was set out that when considering the effect admission of evidence would have on the integrity of proceedings, that this court can have regard to the gravity of the violation. And here it is submitted it was a particularly grave violation. It was grave because at paragraphs 3 and 13 of the pretrial chamber's decision, we see that there was no national law which authorised this search, which authorised the authorities to enter her home. And we see at paragraphs 3 and 13 that the Sri Lankan authorities proceeded anyway, in full knowledge that what they were doing was unlawful. And so this is not a situation of an inadvertent breach of the defendant's rights, of a mistake. This was a situation where the authorities acted in full knowledge that they had no legal basis and that they continued to interfere with her right to privacy nonetheless. Furthermore, the interference with her right to privacy was indiscriminate. We see at paragraph 13 of the pretrial chamber's decision that there was no element of selection in the search which the authorities carried out. In those circumstances, then, it is submitted that this was a particularly grave violation of her rights. And so the court, it is submitted, must consider the gravity of that violation when considering the impact on the integrity of the proceedings. But, Mr. President, it is submitted furthermore that the effect of accepting this evidence, if the court does not find with me today, the effect of that will mean that the court is condoning and accepting the practice of state authorities knowingly violating individuals' right to privacy. And it will set an encouragement for state authorities to continue to act in this manner, as they know that ultimately there will be no effect. The evidence will be admitted nonetheless. And in those circumstances, it is submitted that this damages not just the rights of the defendant, not just the integrity of this trial, but the rule of law itself, the restrictions on the arbitrary use of state power against individuals. And it is submitted for those reasons that this court should rule this evidence inadmissible under Article 69(7). Unless I can be of any assistance at this stage. Yes.
Counsel, you referred extensively to Lubanga. And in Lubanga, it was also stated that the effective punishment of serious crimes has been said to render it utterly inappropriate to exclude relevant evidence due to procedural considerations as long as the fairness of the trial is guaranteed. So my question to you, counsel, is, in this case, was the circumstances of the search not merely a procedural consideration that ultimately did not detract from all of the rights and fairness that the trial process itself is clothed to protect the accused?
Yes, Mr. President. This case is substantially different from Lubanga. This was not a matter of a minor procedural violation. This is not a case where the court is being asked to enter into any consideration of the applicability or the interpretation of national law. Rather, this is a case where there is a total absence of governing national law, where the authorities were aware of this and continued nevertheless, and then proceeded to carry out an indiscriminate search on top of that. And so it is submitted that this case is distinguishable very easily from Lubanga. In that case, it was a violation of a less grave matter than in the circumstances before us here. If it pleases the court, then, I will move to my second submission, and this concerns the airstrikes themselves. And here it is submitted that an armed attack, which is designed to address humanitarian crisis, cannot amount to an act of aggression and cannot be of the character to constitute a manifest violation of the Charter of the United Nations. Mr. President, Article 8 bis requires two components to be met for a crime of aggression. First, there must be an act of aggression carried out by a state which is inconsistent with the UN Charter. Second, that act of aggression must reach a threshold of a character, gravity, and scale, which is a manifest violation of the Charter of the United Nations. And I have two submissions to this. First, that there was no act of aggression, as the airstrikes were humanitarian intervention under customary international law. And second, in any event, that the airstrikes were not of the character to constitute a manifest violation of the UN Charter. So to begin with the first point, it is submitted that a rule of customary international law has developed, which allows for humanitarian intervention in certain limited circumstances. And here it is submitted that this rule arises specifically when the Security Council is blocked from taking action and where states cannot proceed through the ordinary means by Security Council authorization. It is submitted that we see an analogy in the recent airstrikes carried out in Syria in 2017 and 2018. In those circumstances, there was three essential elements. There was the use of chemical weapons against civilians by their own state. The Security Council was at a standstill. A permanent member was exercising a veto, and they could go no further. And third, after the airstrikes, there was an outpouring of a degree of international support and a lack of condemnation of those strikes. It is submitted that the rule of customary international law, which allows for humanitarian intervention, has been developing for the past 30 or so years, but has specifically crystallized recently in the use of intervention against the chemical facilities in Syria. And it is submitted that the airstrikes in Bravos meet those three essential criteria that were present in Syria. First, the government of Bravos was using chemical weapons against its civilians. At paragraphs 5 and 9, we see that 2,200 civilians were killed while exercising their democratic right to strike. Second, the Security Council was at a standstill. We see at paragraph 7 and 10 of the pre-trial chamber's decision that twice the Security Council had attempted to take action to resolve this situation, and twice a permanent member had exercised a veto. And third, we see international support after the airstrikes were carried out. At paragraph 12 of the pre-trial chamber's decision, we see that some members of the Security Council called it necessary in response to humanitarian crisis. It is submitted then that this court should view the airstrikes in Bravos under the parameter of humanitarian intervention, a customary rule which has been established and which has crystallized in response to the international condemnation of the use of chemical weapons. And it is submitted that the airstrikes, for that reason, cannot constitute an act of aggression itself, as required for Article 8 bis of the Rome Statute. Unless I can be of any assistance then, I will move to my second submission here, which concerns the character of the airstrikes themselves. And at Understanding 7, which is the next to the Kampala amendments, this discusses the requirements of character, gravity, and scale reaching a manifest violation. And it is set out there that no one of them is sufficient. Each component must satisfy that requirement of a manifest violation of the Charter of the United Nations. With regard to the character component, this refers to the quality of an act, and here only a use of force, which is obviously and unambiguously illegal under international law, will reach that threshold of a manifest violation of the Charter of the United Nations. Not every illegal use of force will amount to a crime of aggression. It is submitted then for this reason, that if the court is not with me and does not find that a rule of customary international law has developed, which the airstrikes fit within, it is submitted then that the airstrikes do not have the character of being obviously and unambiguously illegal. It is submitted that the debate on the formation of humanitarian intervention has been ongoing in the international academic community for decades. It is a debate that has happened in the International Court of Justice. It is a debate that has happened within state parties, and as set out at Appendix 2 of Dr. Targaryen's opinion, we see that many scholars, including herself, believe that it has crystallized. And it is a debate that this court is having today. For those reasons, then, it is submitted that humanitarian intervention is at the very worst ambiguous, and so it cannot reach that threshold of obviously and unambiguously illegal. Unless I can be of any assistance, then, I will move to my third submission, and this concerns the threshold requirements of Article 25(3)(c). And here it is submitted that a lawyer on commission who provides independent, bona fide legal advice cannot, by virtue of the nature of their function and by virtue of the nature of their relationship with their client, cannot be said to have aided and abetted the crime of aggression. It is submitted here that Article 25(3)(bis), as inserted by the Kampala amendments, sets a specific threshold requirement for aiding and abetting the crime of aggression. This only applies to persons who are in a position, effectively, to exercise control over or to direct the political or military actions of a state. If an individual does not fit that threshold, they cannot be prosecuted for aiding and abetting the crime of aggression. And it is submitted that the defendant does not fall within that remit. On a plain reading of the words of Article 25(3)(bis) and an understanding of the ordinary meaning of those words, as required under Article 31(1) of the Vienna Convention on the Law of Treaties. At paragraph 3 of the pretrial chamber's decision, it is set out that the defendant is a Salantan lawyer and academic. She is not in a formal position of leadership over the state of Astapor or over its political or military activity, and she is not in any de facto leadership position over the same. She could not order them to carry out an action. She could not prevent them from doing so. She could not direct the way in which an action should be carried out, and she could not be determinative in any way upon the outcome of the decision that the Cabinet of Astapor made. It is submitted furthermore that although legal advice can no doubt be influential, it is only one of a number of inputs which will be made into an executive or cabinet decision. The nature of executive decision-making is that it requires inputs from many sides: political advice, economic advice, foreign affair advice, and legal advice is just one of these aspects, just one of these inputs. If the defendant had not provided her advice, the airstrikes could still have gone ahead on the basis of no advice, on the basis of different advice, or going against advice provided. In those circumstances then, the defendant's advice was not determinative of any outcome, and she cannot be said to have fulfilled the threshold requirements under Article 25(3)(bis). For those reasons then, it is submitted that this court must have regard, first of all, to the threshold requirements of Article 25(3)(bis), second, to the circumstances in Astapor and the humanitarian intervention that took place in Bravos, and third, it must have regard to the impact that admitting this evidence would have on the integrity not just of these proceedings, but of all proceedings before this court in the future. And for those reasons, May it please the court.
All right, you could have, I think the rules allow you an additional minute, and I think my colleague has a question for you.
Yes.
So my question is related to the requirements of 25(3)(c as regards the means for commission of crime, to the extent that legal justification in this case was required. Is it arguable that her advice provided the legal justifications to go ahead with the airstrikes? Thanks.
Yes, Your Honour. Even if her advice was of some assistance to the Cabinet of Astapor or to James Bannister, it is submitted that that does not reach the threshold which is required for a prosecution under Article 25(3) bis in the first place. It is submitted that the provision of once-off independent legal advice cannot go near satisfying that threshold. And so for those reasons then, I would ask the court to have regard to the wording of Article 25(3) bis.
Okay, thank you very much. We will now, having listened to
May it please the court.
counsel for the defense, we'll now hear for counsel from the prosecution.
Mr. President, Your Honors, may it please the court. My name is Joshua Young, and I represent the prosecution in this matter. Your Honors, this case concerns the world's leading international legal expert misusing her renown to enable the commission of a grave international crime. On the 28th of July 2018, the state of Astapor invaded Bravos airspace, sending military airplanes that dropped bombs on 3 separate targets that killed and or injured a multitude of innocent Bravos citizens and destroyed significant infrastructure. This reign of destruction from the skies over Bravos was carried out after being knowingly sanctioned by defendant Danny Targaryen, a leading expert in terms of international law. Defendant Targaryen knew that, without her sanctioning, the aerial bombardments that ripped the fabric of Bravos' human life and property would not have occurred. Astapor's president, James Bannister, explicitly told her as much. In light of this, we urge Your Honors to affirm PTC 6's confirmation of charges on 3 separate legal grounds. First, the evidence in the record is admissible under Article 69 of the Rome Statute. Second, Astapor's aerial bombardments manifestly violate the United Nations Charter. And third, through her central role in giving the necessary legal sanction, defendant Targaryen aided and abetted Astapor's crime of aggression. As a threshold matter, Your Honors, the standard of review at the appeal stage is merely corrective and not de novo, pursuant to paragraph 36 of this court's recent Bemba decision, along with the 2012 Umbrashi-Mana decision. Your Honors may only intervene if you find that an error of law, I quote, materially affected the impugned decision below. And second, at the confirmation of charges stage, the standard of proof is merely substantial grounds to believe under Articles 61(5) and 7 of the Rome Statute. With these standards in mind, I now turn to my first submission. The evidence in the record is admissible under Article 69 of the Rome Statute for 3 reasons. First, the evidence is prima facie relevant and probative, and therefore, at the pre-trial stage, prima facie admissible unless any of the limbs under Article 69(7) of the Rome Statute apply. Second, the evidence was not obtained in violation of internationally recognized human rights, and I will focus in my oral presentation in terms of the right to privacy, as it was the only right that my learned friend for the defense alleges was breached in this case. And third, the admission of the evidence would not seriously damage or or be antithetical to the integrity of the proceedings. Again, I'm only focusing on this limb since it was the only limb relied on by defense counsel in their oral presentation. Turning to the first point of submission, Your Honors, as held by this court in the Lubanga decision, evidence that is prima facie relevant and probative at the pretrial stage is prima facie admissible unless any exclusionary grounds under Article 69(7) of the Rome Statute apply. In this regard, the evidence in the record concerns defendant Targaryen's communications with President James Bannister, where she provided the key legal advice required to enable the airstrikes on the facts. And in particular, she opted to change her advice and tailor it to suit President Bannister's needs and allow for the airstrikes to happen. Therefore, this relevant and highly probative evidence must be admissible unless any of the grounds under Article 69(7) apply. Turning then to the first limb of Article 69(7), whether or not the evidence was obtained in breach of internationally recognized human rights. Defense counsel today relies on the right to privacy and asserts that it was breached by the indiscriminate search by Sri Lankan officials in Dr. Targaryen's home. However, this court, in both the recent Bemba appeals decision and the earlier Mbarashimana confirmation decision, has held that there's a presumption of legality in the investigative activities by domestic jurisdictions. And in particular, Your Honor, the record indicates that defendant Targaryen was not cooperative during the search and was arrested by Sri Lankan officials for attempting to obstruct justice. In this regard, from the point of view of the Sri Lankan officials, they simply had no means, Your Honors, to ascertain whose personal belongings they were, whose computers they were, and which items belonged to Dr. Targaryen and which did not, because Dr. Targaryen was simply uncooperative throughout the entire search. And therefore, they had to conduct a thorough search of the house to ensure that they did not miss out on key evidence concerning a very serious and grave international crime. In particular, Your Honors, the record indicates that all they took from defendant Targaryen's home were 4 computers, directly corresponding to the electronic nature of the email communications and the legal advice given by defendant Targaryen to President James Bannister. And therefore, unlike what defense counsel asserts in this case, the search by Sri Lankan authorities is first of all presumed to be in accordance with law, and second of all, there is good reason for them for carrying out a search in Dr. Targaryen's home and involving other family members' belongings, since they do not have, Your Honors, the benefits of hindsight that we do today. But in any event, Your Honors, even if you're not with me on the first ground, the admission of the evidence would not seriously damage and be antithetical to the integrity of these proceedings. In particular, as Mr. President very correctly noted in questioning, this involves a balancing exercise between the seriousness of the violation and the due process protections offered to the accused as held by this court in Lubanga. And in this regard, in the Lubanga decision specifically, the court there found a breach of the right to privacy, especially due to the disproportionate nature of the search. The exact same allegation, Your Honor, as defense counsel is making today. In particular, the search and seizure was so egregious in Lubanga that the court expressly noted in the judgment that there were, I quote, no means to determine the relevance of the items seized, including personal diaries and other personal items from Mr. Lubanga himself. But nonetheless, as Your Honors are very familiar, the court in Lubanga held that this violation was insufficiently serious in order to allow for the exclusion of evidence under Article 69(7)(b) of the Rome Statute. In particular, Your Honors, a few factors are relevant to your consideration here. First, the fact that my office is completely innocent in this seizure of evidence. It was not involved at all in terms of obtaining the evidence and was only handed the evidence on the silver platter by the Sri Lankan domestic authorities on the facts of this case. Second, Your Honors, the fact that we are concerned with a very grave offense here, the crime of aggression, often called the mother of all crimes. And this evidence, as earlier established, is relevant and highly probative to Your Honor's determination. Third, the fact that we are ultimately only at the pre-trial stage, as I have submitted earlier, which means professional judges, like Your Honors, at trial can give due weight to the evidence, taking into account how the evidence was indeed obtained. And furthermore, the procedural irregularities that the defense complains of in the seizure of evidence can also be determined by Your Honors at trial by asking the Cervantes domestic authorities, for instance, to give evidence, instead of putting words in their mouths and asserting that the search was disproportionate and ending the case of this serious crime at this very early stage, Your Honors. And therefore, these three factors militate against excluding the evidence. In particular, when this court in both the Lubanga and Bemba decisions, in considering Article 69(7)b of the Rome Statute, opted not to exclude the evidence on this ground, Your Honors. And therefore, we would argue the violation here is simply insufficient, even if established, to allow for an exclusion of evidence on this basis. Turning then to the second ground of appeal, Your Honors.
Just let me ask you a
Certainly, Mr.
question.
President.
Now, you quite correctly have indicated that your office, the OTP's office at the ICC, was not involved in the search. But now, Lubanga identified three grounds, of which that is one. The first two was the gravity of the procedural violation, and the second one, which is the one that concerns me, is the impact of the violation on the rights of the accused. Now here it is, in this case, the entire proceedings arguably were launched on the evidence that was collected, which you described as just 4 computers. So the question is, and this is of course what was turned over to you, what was the impact of the violation on the rights of the accused insofar as it should be applied to this case?
Your Honor, in this regard, we would submit that the impact of the violation on the rights of the accused is minimal. And in particular, if I may draw by analogy, previous cases where the court also considered the impact of the violation to the rights of the accused. For instance, the ICTY case of Nikolic, which was cited by the ICTY in Berdanen and affirmed by this court in Lubanga, concerned an issue of jurisdiction where the utter kidnapping of an individual by militia forces was still deemed by the court in that case to be an insufficient enough violation to exclude evidence and exclude jurisdiction in terms of that case on this ground. And therefore, as this court has established in Lubanga, Your Honors, the threshold for exclusion is very high, in particular because, as I have mentioned, Your Honors no doubt would take into account the means of obtaining of evidence ultimately when deciding the weight of evidence at trial. And therefore, we would submit that here exclusion would be premature, Your Honors. Unless Your Honors have further questions, I will now turn to the second submission.
Yes.
In this regard, the prosecution would make 3 arguments. First of all, there is no customary international law exception to the use of force prohibition that is humanitarian intervention. In particular, the highest threshold of usus and opinio juris is not made out on the facts in this case and in the world. Second, pursuant to the travaux of Article 8 bis of the Rome Statute, humanitarian intervention does not fall within a legal gray area that is excluded by the manifest wording as alleged by defense counsel. And third, in any event, there is no humanitarian intervention on the facts, as ASIPER had the plethora of alternatives to explore before it carried out the airstrikes in this case. Turning to the first points of submission, Your Honors, it is well established in the International Court of Justice case of Nicaragua that the use of force prohibition in Article 2.4 of the United Nations Charter is a jus cogens norm, a norm that cannot be derogated from in all circumstances, unless under Article 53 of the VCLT, a subsequent norm of the same character forms that is able to temper the previous norm. In this regard, defense counsel has never explained to your honors why customary international law can act as a means to temper an otherwise jus cogens norm of a higher status in this case. In any event, we would submit further that there is no customary international law, even taking my learned friend's case at its highest. In particular, your honors, in their secondary submission in terms of the legal gray area, defense counsel concedes that there is academic debate and huge uncertainty concerning the legality of humanitarian intervention. And in this regard, the International Court of Justice, in its nuclear weapons advisory opinion, noted that general international disagreement as to the legality of a certain thing, in that case, the legality of nuclear weapons, was sufficient to negative the formation of opinio juris for there to be custom. The requirements for custom are high, your honors. There has to be consistent and virtually uniform state practice pursuant to the North Sea Continental Shelf case and also opinio juris. And very briefly, just looking at the 2018 Syrian airstrikes, which the Defense Counsel relies on, they seriously downplay the amount of opposition that this has received. In particular, a total of 12 states have voiced out their opposition to the airstrikes, deeming it illegal under international law and in violation of the United Nations Charter, including states not connected to the intervening countries or the geopolitics in the Middle East, such as South Africa and Bolivia. And further, we would argue that many other states in other situations have argued that humanitarian intervention is not illegal. For instance, the Group of 77, along with the non-aligned movement, comprising namely of 134 and 120 states, both stated that humanitarian intervention is in breach of the use of force prohibition and not allowed for under the UNSC framework. This is also confirmed by the responsibility to protect debates in 2005, where the World Summit reports indicated that the use of force was to be through the UNSC as a last resort, again affirming the intention to abide by the UN framework and not allow vigilante unilateral humanitarian intervention. And therefore, your honors, in any event, Defense Counsel has been unable to establish that there is a customary international law exception to the use of force, nor how customary international law can temper a jus cogens prohibition in Article 2.4 of the UN Charter. Turning then to the last issue before, certainly.
Just one question, Mr. Young. So far, you've only been addressing the question as to whether there is an exception for humanitarian intervention. However, the question before us that was certified for this appeal is not whether there's a humanitarian intervention exception, but whether the facts constitute a manifest violation of the Charter. So the question is not, is it a violation, is it a manifest violation? Now, I assume you're going to argue that it is a manifest violation. My question is, why on these facts? And more particularly, how much lower, because you mentioned that it was going to destroy the fabric of human life and infrastructure, how much lower should the casualty numbers be for it not to be a manifest violation?
Very briefly, Your Honors, although the prosecution does not seek to engage in a line drawing exercise, an analogy can briefly be sought with the gravity threshold under Article 17.1d, which concerned the same factors. And the Flotillas case, for instance, which concerned 55 injuries and 10 deaths, was deemed by PTC to be, I quote, a compelling indicator of gravity. And therefore, by analogy here, the number of deaths and injuries would be sufficient in the record to be a manifest violation of the scale and gravity requirements. Turning then to the last issue, the prosecution wants to make two submissions. First, pursuant to a long line of Nuremberg jurisprudence, individuals who give legal advice to enable the commission of international crimes are liable for aiding or abetting such crimes. In particular, the NMT case of Hans Lammers, where Hans Lammers, a lawyer for the German government, quote, cloaked illegal acts with a semblance of legality, was found liable for crimes against peace. And here, by analogy, in her one-sided legal opinion that was changed after request from President Bannister, defendant Targaryen also cloaked Asper's acts with a semblance of legality and should be liable. Second, Your Honors, defense counsel asserts that defendant Targaryen does not meet the control or direct threshold in Article 25(3) bis. The facts of the case are simple, Your Honors. If defendant Targaryen said yes, Asper's cabinet would go ahead with the airstrikes. If she said no, they would not go ahead with the airstrikes. When she said maybe, President Bannister immediately asked her and paid her money to give a second opinion, to say yes, and then the airstrikes occurred. This clearly, Your Honor, rises above the control or direct threshold required under Article 25(3) bis of the Rome Statute. In particular, because all the prosecution needs to demonstrate at the pretrial stage are substantial grounds. Your Honor, I notice the time. May I be given 1 minute just to conclude my submissions? I appreciate your indulgence, Your Honors. In particular, because all the prosecution needs to demonstrate at the pretrial stage are substantial grounds to believe. As a closing note, Your Honors, as this court held in Lubanga, the purpose of a confirmation hearing is, I quote, to filter charges which consist of mere theory or suspicion, or which are wrongful and wholly unfounded. The present case clearly rises miles beyond this low threshold, Your Honors, and therefore we urge you to dismiss this appeal and allow this case to proceed to a full trial. Thank you, and may it please the court.
Thank you, counsel. Well, having listened to counsel for the defendant, the prosecutor, the court will now hear from counsel for the state of Astapur. So you can now present your submissions.
Mr. President, Your Honours, there is one question which is fundamental to this appeal. Will the crime of aggression prioritise state sovereignty or human life? We are here today in the wake of barbaric chemical weapons attacks orchestrated by an oppressive and cruel regime against its own civilian population. These attacks claimed the lives of at least 2,200 people. It is for this reason that the amicus would like to stress the importance of construing the crime of aggression in the historical context within which it was conceived, namely as a means to hold accountable those who wage aggressive wars or invasions. It is not a tool to be used to persecute and to punish those who stand to act in the wake of mass humanitarian distress. Your Honours, it is a privilege to appear to you today, able to present the unique perspective of both a state party to the Rome Statute and one at the centre of these proceedings. To this end, I will offer 3 observations. I will deal with the grounds of appeal in a different order and one which reflects the issues most pertinent to the state of Astapur. First, it will be observed that the airstrikes in question do not amount to an act or to a crime of aggression within the meaning of Article 8 bis. Second, and on the issue of liability of a lawyer, this will be dealt with in the abstract, and assistance will be offered to the bench on how to dispose of this issue. Third, and relating to the impugned evidence, it will be observed that this evidence should be deemed inadmissible under Article 69(7). If I may, I will begin with our first observation. Your Honours, the amicus is of the view that the airstrikes of the 29th of July 2018 are not an act of aggression which by its character, gravity and scale is a manifest violation of the United Nations Charter. The underlying issue of an act of aggression is dealt with more thoroughly in our written submissions at paragraphs 49 to 70. However, more pertinent to this appeal today, and in the alternative, is the issue of whether a crime has taken place. Your Honours, there are two questions which are determinative or dispositive of the criminality of these airstrikes. The first is, can humanitarian motivations underpinning a purported act of aggression ever preclude a finding of the existence of a crime of aggression? If this is so, the second issue is whether these airstrikes were humanitarian in nature and thereby not criminal. The amicus will answer both of these questions in the affirmative. There are two ways in which Article 8 bis 1 allows for consideration of humanitarian motivations of an act of aggression. The first is through the character and gravity components, and the second is through the requirement of a manifest violation of the United Nations Charter. At this juncture, I would like to remind the Court that illegality of the purported airstrikes has already been established if this Court accepts the existence of an act of aggression. Contrary to the submissions of the prosecution and of the defence, it is our position that we do not need to prove the existence of a norm of customary international law in order to preclude a finding of a crime of aggression. We would like to distinguish between the purported doctrine of under international law of humanitarian intervention and humanitarian motivations which may be relevant under Article 8 bis 1. Rather, if we turn to a discussion of the components and the threshold requirements of character and of gravity, we see that these threshold requirements were deliberately included into the drafting of Article 8 bis 1 as a means to open consideration for the nature and for the effects of a purported act of aggression, which may already be illegal. As such, if humanitarian motivations underpin and are determinative of the nature of an act of aggression, then these acts of aggression will not meet the threshold requirements of being of a character or a gravity to constitute a manifest violation, and thereby they will not be criminal. Turning to the requirement of a manifest or an incontestable, unambiguous violation of the United Nations Charter, to reiterate, mere breaches of Article 2.4 do not amount to manifest violations of the entire United Nations Charter. Interventions on the basis of humanitarian motivations are not clear or unambiguous violations of the Charter of the United Nations. We can see this through the examples brought in by both counsel for the defence and the prosecution. If we look at the motivations underpinning the airstrikes in Syria last year, or indeed the NATO intervention of 1999, we can see that the bulk of states relied on issues of a humanitarian nature. Only 2 states relied on humanitarian intervention explicitly. However, the preclusion of further chemical weapons attacks is a humanitarian nature underpinning airstrikes. And as such, given the utter lack of condemnation by the United Nations General Assembly or the United Nations Security Council in both of these situations, we can see that were clear and unambiguous breaches of Article 2.4 were not clear and unambiguous breaches of the general prohibition on the use of force. They were not manifest violations of the United Nations Charter. This provides an opening to consider humanitarian motivations as excluded from Article 8 bis 1. And this answers my first question in the affirmative. Indeed, humanitarian motivations can be determinative of the existence of a crime of aggression. Moving on to my second question, we would observe, yes, Your Honour.
I take it you have finished on this point?
Yes.
Yes, so then before you go on, I have a question. You seem to put a lot of stock in the fact that the strikes were meant to avert further chemical weapons use. Now, if my understanding of the facts is correct, your own strikes struck chemical facilities which were located very close by the capital city, and therefore entailed a certain risk that that population would also be exposed to chemical fumes and what have you. Now, in this case, you may have been lucky that nothing happened. So to what extent is the fact that you took that risk relevant in our consideration of your motives?
Your Honours, this is a risk which is inherent to any operation to destabilise chemical weapons facilities. Alternatives which might have been available, which I'm sure the prosecution will no doubt raise, include, for example, stopping the licensing of an Astor company from selling chemicals such as chlorine to the state of Bravos. However, these alternatives would not be efficient. The most efficient way to stop these attacks from reoccurring was to target the facilities which the government of Bravos were using to initiate these attacks. And of course, collateral damage, whether it be environmental, whether it affect a population in another way, is always regrettable. However, there is an exercise in balancing when we look at how to preclude mass atrocities such as the one before us today. Your Honours, this brings me to the second issue, namely demonstrating that the airstrikes at issue were indeed humanitarian in nature and thereby not criminal. First, Your Honours, I would direct you to the desperate situation which the people of Bravos faced. Thousands had been massacred in what the government of Bravos did, which was execute immediate chlorine bomb attacks following the protests to unfair working conditions. Peaceful attempts at dispute settlement before the United Nations Security Council had unfortunately failed. What the state of Astapa did was decide to take action, and it did so in a limited and brief manner, which was successful in disabling these chemical weapons facilities. As such, we can see that the strikes were humanitarian in nature, and therefore they were not criminal under Article 8 bis 1. The development of the United Nations Charter, in the way it's been interpreted over the last 7 decades, has told us that the law on the use of force is not static. And at least in the context of the crime of aggression, interventions on humanitarian grounds can no longer be condemned as impermissible and an impermissible option for states to take in such dire circumstances. As such, we would argue that the airstrikes at issue do not amount to a crime of aggression, and this concludes our observations on the second issue of this appeal. Your Honours, to address the issue of lawyers' liability, the third ground of appeal, we would like to begin by reaffirming the limited and somewhat conflicted position which the state of Astapa takes up in these proceedings. There are ongoing proceedings before this court against members of our own government. Naturally, we would not want to prejudice these proceedings, and nor is our purpose today to play second fiddle to the defence. We hope you can appreciate our decision to address the third issue entirely in the abstract and in line with the way the issue was formulated by this chamber at paragraph C of the established agenda on page 1 of the facts. To begin with the leadership requirement at Article 25(3) bis, the position of the amicus is that this leadership requirement does indeed allow lawyers to be liable for the crime of aggression. Being both a government and a party to the Rome Statute, we are in a particular position to appreciate the significance which lawyers and their advice can have on the actions of a state. Further, Article 25(3) bis has no requirement of a formal position of direction or control, and nor does it explicitly exclude lawyers. Therefore, if a lawyer is commissioned specifically to decide on issues of military or political action of a state, then they may well meet this position of direction and of control. Turning then to the issue of aiding and abetting. This court is yet to adopt a conclusive interpretation of Article 25(3)(c). To assist the court, we will offer an interpretation of the components of this provision. Beginning with the actus reus, aiding and abetting is the rendering of practical assistance, encouragement, moral support to the commission of a crime. Looking then at causality, the ICC has issued conflicting opinions on the issue of a causality requirement. In Barashamina at paragraph 279 and in Lubanga at paragraph 997, it endorsed a substantial effects requirement. However, in Bemba et al., this chamber held that no such requirement of a causal relationship exists. And indeed, we would endorse some sort of a causal relationship in line with the concept of facilitation within Article 25(3)(c). Looking briefly at the issue of mens rea, we would observe that purpose, in line with the judgment of the Bemba trial chamber, has a slightly nuanced difference to that of intent at Article 30, and as such, it has a slightly higher threshold. This concludes our observations on the third grounds of appeal. Turning then to the final issue of evidence. Co-counsel for the prosecution and for the defence have both noted the two-stage test at Article 69(7) for the exclusion of evidence. The position of the amicus on this issue is that there has been a violation of the defendant and of her family's right to privacy, and that admitting evidence would be antithetical and would be seriously damaging to the integrity of proceedings. The issue of reliability, to briefly focus on this, is not something which the amicus will go into a great deal of detail on here, as it is, according to the Barashamina confirmation of charges decision, an issue better discussed at the trial stage. Turning to the right to privacy, we would observe that there has been a violation here. The appeals chamber in the recent Bemba et al. Decision on evidence acknowledged that the internationally recognized right to privacy may only be interfered with when such an interference is in accordance with law and when it is necessary or proportionate for the protection of important public interests. We can see here, according to paragraph 13 of the facts of the case, that there was no legal basis whatsoever. There is no law, no domestic law for this court to interpret or to apply. There was simply no domestic legal basis for this search. This, in and of itself, is indicative of a human rights violation. Moreover, the disproportionate nature of the search, the fact that it was indiscriminate and unannounced, also relates to the utter privacy violation which we see here. Turning then to the issue of the actual admission of evidence and the second part of Article 69(7, counsel for the defence have raised the relevance of the gravity of a violation. We would add that the materially aggravating circumstances here are the arrest and the non-compliance of the defendant during this nighttime search, and the fact that she was subsequently detained for months on end, pending a warrant which may or may not have ever been issued by this court. Unlike in Lubanga, where the evidence was ultimately admitted, it was also the defendant's rights that were directly attacked. This demonstrates how unfair it would be to admit this evidence, where the defendant here is at the whim of the resources of the state and of the Office of the Prosecution, and the equality of arms principle is so gravely undermined. Your Honours, for these reasons, we would argue that the evidence should be deemed unadmissible under Article 69(7). If I may, I will conclude our observations. We would like to remind the court of the standard of appeal that the defence must meet in order to demonstrate the existence of the fact that the pretrial chamber's decision should be changed. There must be an error of fact or of law which materially affected the pretrial chamber's decision. The amicus would observe that on the issues of evidence and a crime of aggression, this has been demonstrated today. To close, we would restate our opening question and bid this court not to treat its newest crime as a means to subjugate human life to state sovereignty. Unless I can be of further assistance, Your Honours, this closes the observations for the amicus.
Thank you. Well, the two parties and the participants have raised very important points, bearing in mind that this case constitutes several firsts for this court. It's the first case that the court has dealing with the crime of aggression. It's the first case to address whether a lawyer can be tried for legal advice. And it's the first case to address the admissibility of evidence in ICC proceedings where such was obtained by domestic authorities in an unlawful search. So it's meaty issues. So I think it's deserving of each of you having the opportunity to respond. So each party will now be given in the same order the possibility to reply to it. I would like to remind you that in this instance, you are each allocated 10 minutes and that no team will be given more than 10 minutes for their rebuttal. Counsel for the defense, you may begin.
Mr. President, Your Honours, may it please the Court. Counsel for the defence wishes to submit 4 points in rebuttal. First, in relation to the counsel for the prosecutor's submissions, that this evidence should be admitted because of the seriousness of the crime with which the defendant is charged. I will argue that this is an error of law. Secondly, in relation to the submissions of the prosecutor, that the prohibition on the use of force between states is a jus cogens norm. I will agree, but I will say and submit that humanitarian intervention is consistent with the UN Charter and has developed as a further exception to the prohibition. Third, in relation to counsel for the prosecutor's reliance on the Nuremberg precedents to show that independent lawyers can be held accountable for aiding and abetting the crime of aggression, I will submit that this is an error of law and that it is no such authority. And finally, in relation to the submissions of the prosecutor, that the violation of the defendant's right to privacy was proportionate because they did not have the benefit of hindsight and there was no other option available. I will argue that this approach damages the integrity, not just of this trial, but potentially of all trials before this court. If it pleases the court then, I will begin with the first submission. And here, counsel for the prosecutor has argued that the evidence should be admitted because of the seriousness of the crime of aggression itself, as it is the mother of all crimes. This is an error of law. The seriousness of the charge against the defendant is not a relevant factor under Article 69(7) inquiries. At paragraph 44 of the Lubanga Bar Table decision, the Chamber set out that the seriousness of alleged crimes is not a relevant factor for admissibility of evidence under 69(7). And this makes sense because, of course, every crime before this court is serious. As per the preamble to the Rome Statute, this court is only concerned with those most serious crimes of international concern. However, Article 69(7) sets out to do something very specific. When a person is charged with one of the most serious international crimes, this court still provides them protection. Protection from disproportionate interferences with their human rights, and protection from the admission of evidence against them, where doing so would be antithetical to and would seriously damage the integrity of proceedings. For those reasons, Article 69(7) simply looks to the circumstances of the violation and not the seriousness of the crime with which the defendant is charged. To move then to my second point of rebuttal, and here, counsel for the prosecutor submitted that the prohibition on the use of force is a jus cogens norm, as per the Nicaragua judgment. And this is correct. However, the prohibition under Article 2.4 of the Charter of the United Nations includes exceptions. It includes the exception of self-defense. It includes the exception of Security Council authorization. And it implicitly includes an exception for actions which are consistent with the principles and policies of the UN Charter. And it is submitted that humanitarian intervention is consistent with those aims. The promotion of human rights is one of the primary purposes of the United Nations, as per the preamble, as per Article 1.5, as per Article 55. And this court can use the subsequent development of law and UN practice to interpret the Charter, as the International Court of Justice has done in the Namibia decision and at paragraph 140 of the Gabjikovo-Najimaris project. The decision in Nicaragua was made in 1986. The state practice and opinio juris of humanitarian intervention has developed almost entirely in the last 30 years. But this is not the bar to a formation of a new rule. A rule of custom can develop quickly. It requires consistency, but not complete universality. Rather, this court can have regard to specially affected states, as per paragraph 73 of the North Sea Continental Shelf decision. And the International Law Commission on the Identification of Customary International Law in their 2018 paper said that specially affected states are really where the court must have particular regard to when identifying state practice of custom. It is those states that have the ability to carry out a new rule of custom, and it is those states that have the will to carry out that action. And here it is submitted, although of course the examples of state practice of humanitarian intervention are not universal, but the court can have regard to those incidents and consider them as specially affected states. Yes, Your Honour.
Very brief question. You mentioned that we should look particularly to the states that are involved. Should we also then look at the states that are at the receiving end of humanitarian intervention? And to what extent can they be considered persistent objectors?
Yes, Your Honour. The court, of course, can have regard to the behaviour of any state parties, including those states which are on the receiving end of humanitarian intervention. It is submitted that if a state made its objection known at this stage to humanitarian intervention, it could be seen as a persistent objector if this court finds that the rule has already crystallised. And so in that regard, the state of Bravos perhaps could be seen as a persistent objector to the doctrine if the court considers it's crystallised at this stage. To move then to my third point of rebuttal, and here counsel for the prosecution said that the Nuremberg precedents show that lawyers can be prosecuted for aiding and abetting the crime of aggression. Mr. President, of course lawyers can be prosecuted for aiding and abetting the crime of aggression if they're in a position where they can fulfill the threshold requirements under Article 25(3) bis. The case law that the prosecutor has cited refers to lawyers who are members of the Nazi Party, who are policymakers, who are actively engaged in furthering the aims and missions of that corrupt state. In those circumstances, that is not authority for saying that an independent third-party lawyer can be prosecuted under Article 25(3)(c). For those reasons, I would ask the court not to have regard to that jurisprudence and in fact follow, as was set out by the drafters of the Rome Statute, to follow their wishes and intentions when they explicitly excluded the shape and influence standard from the Nuremberg tribunals under Article 25.3c. Finally then, to deal with my last point of rebuttal, and here counsel for the prosecutor has argued that the interference with the defendant's right to privacy was not disproportionate, as only a number of computers were seized, the information seized was minimal, and it is only with the benefit of hindsight that it is claimed this was a violation of the defendant's right to privacy. Mr. President, Your Honours, this interference was disproportionate because state authorities entered her home illegally, her family home. It is disproportionate because the state of Salanta had other options which they did not pursue. They could have come to this very court under Article 14. They chose not to do so. 24 hours, less than 24 hours after the attacks, they entered her home, they searched her possessions, they seized her belongings. But furthermore, I would ask this court to have regard to the purpose of Article 69.7. And I would ask this court to consider that no matter how grave the circumstances, no matter how serious the crime, no matter how probative the evidence, that rights of defendants before this court must be upheld. They must not be disproportionately breached arbitrarily by state authorities, as otherwise Article 69.7 is nothing more than empty words and will offer no protections. May it please the court.
Would you like another 1 minute, or are you closed?
No, thank you, Mr. President. I am concluded my submissions now,
Okay,
unless
thank you
I
very
can
much.
give any further assistance.
Thank you. Well, then I'll now turn to counsel for the Office of the Prosecutor.
Mr. President, Your Honours, may it please the court. The prosecution would like to make 4 points in rebuttal. Firstly, addressing defense and government counsel's concern as to whether or not the search in Salanta was in accordance with law, Salantan domestic law. Secondly, addressing the issue of whether humanitarian intervention is a customary international law exception to the use of force prohibition. Thirdly, dealing with the defense and government's contention that the delegates at Kampala intended to exclude humanitarian intervention by using the word manifest in drafting Article 8 bis of the Rome Statute. And fourthly, addressing the defense's submission that Nuremberg jurisprudence is inapplicable in terms of determining the interpretation of Article 25.3 bis. Turning to the first submission, Your Honours, both defense and government counsel today allege that the search in Salanta was not in accordance with domestic law and therefore, by extension, violated the right to privacy. However, the prerequisite to that determination and that argument to fly is whether or not the search was in the first place in breach of Salantan law. And this exact determination, Your Honour, as held by this court in its Bemba appeals judgment, is not a determination that this court has jurisdiction to make under Article 69.8 of the Rome Statute. The appeals chamber in Bemba held, and I quote, that there is an unequivocal separation between the respective competences of international and domestic legal systems. And under Article 69.8, Your Honours are not able to venture into whether or not the search was indeed in breach of domestic Salantan law. And therefore, both defense and government counsel's arguments in terms of the prescribed by law requirement are mistaken because Your Honours are not empowered to conduct the prerequisite inquiry as to whether or not there has been a breach of Salantan law. Turning then to the second point of rebuttal, as to whether or not there is a customary international law of exception to the use of force prohibition in humanitarian intervention. Defense counsel in her rebuttal just now relies on the International Court of Justice Namibia decision for the proposition that customary international law can modify jus cogens norms. However, the specific provision of the United Nations Charter in the Namibia decision was Article 73 which concerns the rights of self-determination, and the issue was whether or not a League of Nations trust should continue to apply to Namibia, after the United Nations was formed. The consideration by the court was simply not a use cogens prohibition within the UN Charter, which elevates the use of force prohibition above that of, for instance, Article 73, which the court determined could be tempered by customary international law. And therefore, the Defense Counsel's reliance on this case is misguided, in particular due to the very different nature of the two provisions that Your Honors are asked to interpret in terms of this very case. Turning then to the third point of rebuttal, and whether or not humanitarian intervention is a manifest violation of the United Nations Charter. The travaux préparatoires of the drafting of Article 8 bis indicates that the manifest threshold was actually not intended by delegates to exclude humanitarian intervention. In particular, Professor Klaus Kress and Dr. Stefan Beriga, in their 2017 treatise, The Travaux Préparatoires of the Crime of Aggression, note at page 1181 that, I quote, humanitarian intervention is not, in fact, a gray area when it comes to aggression. This was because leading experts in the use at Bellum Field do not consider humanitarian intervention to be a gray area. And therefore, even at the drafting of Article 8 bis of the Rome Statutes, the delegates did not intend a manifest threshold to exclude acts of humanitarian intervention, but rather observers note that this was intended to exclude conduct such as minor frontier incidents involving border patrols or coast guards, not aerial bombardments on the facts of this case. That is conduct expressly recognized in Article 8 bis 2 of the Rome Statute. And further, this is also supported by the fact that the US intention to introduce draft understanding number 3, which would expressly allow humanitarian intervention to be an exception under Article 8 bis, was resoundingly rejected by the delegates at Kampala. And the observers note, I quote, the overwhelming majority did not seem to favor the proposed US understandings, and there was no agreement as to the substance of the US proposal in the previous text that I have just cited. And therefore, the drafting history, Your Honors, of Article 8 bis shows that humanitarian intervention was simply not intended to be excluded from the definition of a manifest violation. But even if Your Honors are not with me on this first ground, and responding to Government Counsel's assertion about a humanitarian purpose, there is simply no humanitarian intervention on the facts, as PTC 6 found that ASTIPR's airstrikes were pretextual. They specifically targeted the ability of a developing country and economic competitor in Bravos to effectively halt these strikes and enable miners to get back to work. This airstrike removed the ability of Bravos to keep control over its cobalt exportation, and rather allowed for these miners to argue for instance, increase in wages, which ultimately would reflect negatively in terms of the world cobalt market. And this is supported by ASTIPR asking specifically in paragraph 11 of the facts for an embargo on cobalt from Bravos, not anything else, but specifically cobalt, the sole item that was in competition with Bravos in terms of the world economy. And this further establishes that there's not a humanitarian motive behind the airstrikes. Turning finally, yes, Your Honor.
Before you go on, you say that humanitarian intervention was not conceived as being part of an exception and so forth. However, the standard does speak of the character of the use of force. What do you think that refers to? Because counsel for the state has mentioned that, well, it's not about humanitarian intervention, it's about humanitarian motive. Isn't the motive part of the analysis of character? And if not, what does character refer to?
Your Honor, character refers to the nature of the crime, of the alleged act of aggression that occurred. And indeed, motive could be part of a consideration. But as I earlier submitted, the motive here is simply not humanitarian. And the pretextual dominating motive here means that in any event, Your Honors, you can't find that the humanitarian intervention is an exception under Article 8 bis. Turning to the last point, the drafting history of Article 25.3 bis indicates that the delegates intended to actually rely on Nuremberg jurisprudence, which the delegates noted, I quote, the judges would take into account, end quote. The formulation of Article 25.3 bis was, I quote, not intended as a retreat from Nuremberg jurisprudence, end quote, but rather it embraced the exact same standards as in the Lammers case I cited in my main submissions that would apply in interpreting Article 25.3 bis. And in particular, defense counsel's distinguishing of the Nuremberg precedents is simply a matter of form, Your Honors, and not of substance. Because in particular, the delegates noted in the travaux that the application of Article 25.3 bis would include, and I quote, individuals outside of formal government circles, end quote, indicating that they wanted to look at substantially how these individuals could control or direct the political or military apparatus of a state. Your Honors, noticing the time, may I be granted 1 minute to wrap up my rebuttal?
Granted.
Thank you very much for the court's indulgence, Your Honors. And therefore, the delegates evinced an intention to not look at form, but of substance, and in particular, examples such as spiritual leaders, religious leaders, and even intelligence officers, who in specific cases could have huge impacts on the carrying out of an act of aggression, but nonetheless did not have formal government title or rank, were considered by delegates to be able to fall within the leadership requirements. And analogously, we submit that defendant Targaryen is liable. As a result, we urge Your Honors to dismiss this appeal and allow this case to proceed to a full trial. Thank you, and may it please the court.
Thank you, counsel. We'll hear the last word from counsel for the state of Astapur. You may now have the floor.
Your Honours, the amicus will make 5 brief points in rebuttal. Firstly, turning to the issue of evidence, we would like to raise the alternatives which Salanta may or could, indeed should, have explored before they decided to violate the rights of the defendant. We know from Article 86 of the Rome Statute, and indeed the recent Jordan decision issued by the Appeals Chamber, that states have a general duty to cooperate with the court. The importance of cooperation with the court is fundamental for the court's ability to exercise its jurisdiction. Something which the state of Salanta could have done would be reach out to the OTP and seek cooperation from the court as a means to obtain this evidence. Counsel for the prosecution, in his initial submissions, related to the Office of the Prosecution's non-involvement with the search as a means to admit the evidence. The lack of involvement of the Office of the Prosecution should not be a backdoor means of bringing in unlawfully obtained evidence just because the prosecution was not directly involved in its procurement. Rather, we would urge this court to look at nurturing a relationship of cooperation between states, the Office of the Prosecution, and the court more generally. Turning to the issue of probative value, which is something the prosecution stressed in his initial submissions, we would note from the off that this bench today is barred from considering issues of the probative value or the reliability of the evidence. Probative value of evidence is relevant at the Article 69(4) stage of deciding whether or not to admit evidence. The Lubanga trial chamber, and indeed the separate opinion to the Bemba et al. Decision of 8th of March 2018, made it clear at paragraph 32 that issues of probative value are not relevant to a discussion under Article 69(7), which is a provision which is lex specialis to 69(4). In the words of the court in Lubanga, it is impermissible to bring in issues of probative value at this stage. Although this is not a human rights court, Article 21(3) of the statute places human rights in as high a stead as the statute itself. If these issues are not dealt with here and at this stage, then when should they be addressed? Turning to my third point of rebuttal, relating still to the issue of evidence and domestic legality, I would like to make a very simple point of rebuttal. This is an issue of, once again, state sovereignty versus human rights. Article 69(8) was drafted to protect state sovereignty, and of course, intricate inquiries into issues of domestic law are barred, rightfully so, by the statute. What should not be barred, however, is a consideration of whether or not any legal basis existed and the impact this would have on a human rights violation. This is a very clear policy argument. Turning then to the second ground of appeals, counsel for the prosecution raised in his rebuttal the fact that the airstrikes of the 29th of July were allegedly not humanitarian because they were actually economic or political in nature. Your Honours, we would note that the competition in the cobalt market between the state of Astapa and the state of Bravos has been ongoing for approximately 3 years. This is ample time for which the state of Astapa might have decided to step in and boycott the economy in a number of different ways. Of course, what happened here did not relate to the economic issue of competition over the cobalt industry. Rather, only when human rights violations escalated in Bravos to this level did the state of Astapa choose to act. It did not go and bomb the mines where cobalt was being mined for. What it did was target the chemical weapons locations. Turning to the issue of embargoes, we know, of course, from Article 41 of the UN Charter that embargoes are a perfectly legitimate course of action in such circumstances. We can see this from North Korea and the luxury goods embargo in 2006, or Somalia and the 2012 coal embargo, all of which were legitimate responses to acts of terrorism and indeed to testing of nuclear weapons. Your Honour, lastly, I would like to turn your attention to the consequences of the airstrikes at issue. Had the airstrikes been carried out in a strictly legal manner, in line with the Collective Security Project and all of the provisions of the United Nations Charter, would they have been any different? The answer is no. The use of force would have been identical. The number of strikes would have been identical. The location of the strikes would have been identical. Regrettably, the number of victims would almost certainly be similar. And most importantly, the consequences of the strikes would have been identical. Tools used for repression were ultimately taken out of the hands of criminals. To end our submissions, we are a state who has to operate within international law and who is faced with a very unenviable choice. If not us, who? And if not now, when? Thank you, Your Honours.
Thank you, Counsel. I have to say the standard has been exceptionally high. You have given, each team has given the bench a very difficult task. We would now have to retire and give very careful deliberations to see how we separate this very high standard demonstrated by each team. You have not made our jobs easy. All right, so the chamber will rise, and you may leave the courtroom. We will return for 16:45. And by that time, we would have arrived at a solution, at an answer.
All rise, veuillez vous lever.